Former President Jacob Zuma and the uMkhonto weSizwe party will today face off with the SABC in the High Court in Johannesburg over the use of the term Government of National Unity. Now, MK filed its papers on an urgent basis back in July. The new political party is asking the court to, among other things, declare the SABC's continued use of the term unconstitutional and invalid, alleging that it constitutes a breach of the public broadcaster's independence and public mandate. Watching developments for us is SABC News reporter Canny Maphanga, who's live to us now from just outside court. And so, Canny, we know the thrust of the kind of argument MK is making. SABC is opposing this bid. On what basis is the institution pushing back?
Well, indeed, good morning to you, Ayanda, and to the viewers at home. Well, it's another day and yet another court application by the uMkhonto weSizwe political party. This time, it's against the SABC, as you've correctly stated, against the term Government of National Unity, or GNU. The uMkhonto weSizwe political party will be challenging the SABC's use of that term in the urgent court before Judge Yakub this morning when proceedings kick off at 10 a.m. Now, what we understand is that the MK party is arguing that because SABC follows a public mandate to millions of South African citizens, that is viewers and listeners, that rely on the SABC as its primary news source, they have a quote-unquote responsibility to report accurately, and it is the MK's legal position that the current political day that we see in South Africa, or the political arrangement that we see, hardly fits the definitional elements of a GNU, arguing that the SABC is allegedly deliberately misleading the public by using the term GNU, or Government of National Unity. Now, Ayanda, we know how this term came about when we participated in those 2024 national and provincial elections, those hotly contested elections. The ANC, which we've known for majority of our democracy as the majority party, failed to secure that majority in the 2024 general elections, prompting this changing political landscape and having to adapt to the needs of the electorate as we see them now. That brings in the 7th administration. We saw the president form what was called the Government of National Unity, and that is how the reporting has taken place. The SABC has filed papers on the eve of this application, that is yesterday, where they'll be vehemently opposing this bid by the MK party. We know they've said that these allegations are untenable, but of course they'll be advancing that, one, this application is not urgent because the MK party has not shown why it can't get the relief that it seeks now in due course on an ordinary court roll where you can deal with the substantive issues that are needed in this application. Two, they're stating that they're challenging the use of the term based on the fundamental rights in our constitution. However, the MK party in its founding affidavit has failed to explain how the SABC in its use of the term is breaching those fundamental rights that are afforded to all in South Africa who live in it. And then, of course, they'll argue that they want costs because they're saying that this is an abusive process and a vexatious litigation, saying that the MK party is not protected by the buyer watch principle. Remember, that principle deals with public interest litigants who will bring an application against another litigant based on the constitution or fundamental rights that are being asserted. And when you bring an application in that manner, you are protected from the fear of costs should you lose that application. But because the SABC is arguing that this is a flawed application and an abusive process, they will argue that they are entitled to costs and that the MK party is not protected by the buyer watch principle. They'll also further argue that the SABC has a number of internal processes as well as other bodies that govern how the SABC reports in order for those complaints to be met before you could even come before a Gauteng High Court or an urgent court to try and seek this relief. And then, of course, they'll highlight freedom of expression and the independence, or the importance rather thereof, of the independence and impartiality of an institution such as the SABC, and how relief such as this that the MK wants, if they're successful, actually amounts to a court and a political party dictating to a newsroom how they report and how they guide their editorial decisions, which is could be quite a dangerous precedent to set for courts if they were successful this morning. We expect, however, when proceedings start at 10 a.m. that the MK Council will likely deal with the filing from the SABC on the eve of the application. That will probably be a bone of contention, and I don't see a scenario where they'll be able to deal with the significant substance or merits of this application in the urgent court this morning.